Welcome. You're watching the Newshour Agenda, India's most loved primetime show at 10. I'm Padmaja Joshi. Today, something quite dramatic has happened in the district court in Varanasi. The district court held that the pleas filed by 5 Hindu women seeking worshipping rights inside the Gyanvapi mosque compound is maintainable, which means that the suit of the Hindu worshippers will now be heard further. The next hearing is on the 22nd of this month. What will happen in court next? Now, there is the way which has been paved for the Gyanvapi survey to be brought up before the court. Remember the survey we told you about, where very clear Hindu motifs had been found in the Gyanvapi compound and in the basement, where you could see Trishul, you could see lotus figurines, you could see figurines that look like that of Hindu deities. That survey will be put before the district court. Hindu petitioners now also are going to ask for an ASI survey, that is one by the Archaeological Survey of India, and that the shivling-like structure which has been found in the wuzu khana of the Gyanvapi mosque should be subjected to carbon dating. That will determine whether it existed even before the time that the mosque was built. Essentially, they are going to ask for the character to be determined. What was also very important though is that in today's judgment, the court very categorically said the Places of Worship Act does not apply to the present case. Why do I underline that? Because time and again, every time somebody asks for a right to worship in any disputed property in our country, it was said, there's the Places of Worship Act. Places of Worship Act doesn't allow you to even go to court in the case of Kashi. Today the court said that doesn't apply. Why? Because even if the court was to allow prayers inside the disputed structure in Varanasi, it doesn't change the character of the place at all.
कोर्ट ने मुस्लिम पक्ष को अपना जवाब दाखिल करने के लिए कहा है और 22/9 में इसकी अगली तारीख लगाई गई है। इस जजमेंट के बहुत बड़े मायने हैं, क्योंकि जो हमारी कमीशन की रिपोर्ट है अब वो पढ़ी जाएगी, उसके खिलाफ उनको ऑब्जेक्शन देना पड़ेगा और जो कमीशन की रिपोर्ट में शिवलिंग बरामद हुआ है अब उसमें आगे बात होगी। ये सारी महिला याचिकाकर्ताओं के लिए बहुत बड़ी जीत है।
हम लोग आगे इसकी अपील करेंगे, क्योंकि ये आर्डर हमारे लीगल हिसाब से भी सही नहीं है। हाई कोर्ट करेंगे, हाई कोर्ट जाएंगे। तो अभी ये जो 22 उसके पहले हम जेल में हाई कोर्ट जाएंगे। सुनवाई शुरू होती है तो अगला यहाँ पर क्या स्टेप होगा? यहाँ पर कोई, वहाँ हाई कोर्ट में जो होगा हाई कोर्ट से आर्डर होगा, वहाँ के आर्डर होने के बाद यहाँ कोई होगा, देखा जाएगा।
Naturally, there was much jubilation after this verdict, but there was also the familiar attempt to drum up fear and paranoia. Almost immediately, from the All India Muslim Personal Law Board to the AIMIM to the Raza Academy to the PFI, the refrain was the same. India is now being pushed through this one judgment into the dark ages, and this is but another step in the overall fascist agenda of the Modi government in particular, and the Indian state and its people in general.
आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज के ऊपर, और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं फिर। तो ये हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा। मगर अब लगता है कि इस तरह का लिटिगेशन अगर आगे बढ़ेगा तो फिर ये उसी रास्ते पर जा रहा है जो बाबरी मस्जिद का लीगल इशू गया था।
कि ज़िले कोर्ट ने जो फैसला दिया है वो मुसलमानों को सुनकर बड़ा अफसोस हुआ। उसके बरखिलाफ ये फैसला आया है बनारस ज़िले कोर्ट का। मैं समझता हूं कि अपर कोर्ट में ये इसके खिलाफ फैसला होगा।
मस्जिद की पैरवी में मुकम्मल तरीके से, बाज़ाब्ता तरीके से, पूरी ताकत और क़ुव्वत के साथ लड़ाई लड़ी जाएगी, कानूनी लड़ाई लड़ी जाएगी, और कानून की जितनी भी कोशिशें हो सकती हैं वो तमाम ताकतों का इस्तेमाल किया जाएगा।
Which brings us to the main question. Is the celebration and the fear-mongering both premature in the present case? Let the court at least finish its hearing. The court, even if it eventually rules in favor of the petitioners, will only give the right to pray, not right to property of the Gyanvapi Masjid. Similarly, when the issue is going through the entire route of the legal process, why bring up the favorite bogies of fascism and Hindu majoritarianism, except that perhaps this is important more for the politics of the people who are engaging in this fear-mongering than caring for the rights of the worshippers.
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
Alright, joining us on the debate, Kamru Choudhury, leader of the Congress, Shoaib Jamai, president of the India Muslim Foundation, Zubair Memon, political analyst, Shriraj Nair, national spokesperson of the Vishwa Hindu Parishad. But my first question is to one of the people who knows the case very, very closely, has fought the case, Hari Shankar Jain, who's the lawyer in the present case as well. Hari Shankar Jain, I want to start by asking you, a lot of people today are confused, thinking that, oh, this means कि अब शिवलिंग की पूजा होगी. Isn't that a little premature? Because today's judgment is only about the right to worship, not about getting ownership of the Gyanvapi mosque or the Gyanvapi compound.
Yes, you are right. Actual position is, I filed 6 cases. This was the 6th. And in other 5 cases, the question of ownership, the question of removal of mosque forever, that prayer is there. It will affect so many cases, depending cases. Number 2, the religious character of the property is of Hindu property, of temple. Number 3, Place of Worship Act will not apply to any other suits pending before the district court. Now you see, we have prayed that the puja which was going on till 1993 be continued. That was restrained by government of Mulayam Singh in 1993 by erecting barricading, fencing, iron fencing, and Hindus were ousted from the premises. And not only that, the pujari who was worshipping in Tehkana, he was also dispossessed. Now the question, one question would be whether in free independent India, atrocities committed in the past, the temple demolished in 800 years, why it can't be restored? It should be restored.
So let me ask you this, just to make it clear for our viewers, you are saying this is step 1. अभी आप कह रहे हैं कि अभी पूजा की इजाजत दी जाए, ये तो 6th plea पे हियरिंग है. उसके बाद आप कहेंगे कि ये मंदिर है और इसका हक हमें दे दिया जाए, मालिकाना हक हमें दे दिया जाए. Is that what you are pleading before the court as the next step?
Yeah, this suit is also already pending. Suit for ownership and for entire area, that is pending. And the Shivlingam, which was discovered on 16th, that is a new thing. That will be pleaded. There will be pleading to that effect.
But
now we will do the needful so that
okay, so but there could also be the possibility, hypothetically speaking, that even if the district court in Varanasi rules in your favor in this one case, case number 6, they say okay, आप जा करके वहां पूजा कर लीजिए, बट मालिकाना हक आपको नहीं देंगे, या तो ये मस्जिद ही है, आप जाके श्रृंगार गौरी की पूजा कर लीजिए, ये भी हो सकता है.
No, that is not so simple. The deity Lord Shiva, which emerged on 16th May, is deity under Hindu law, and he is a right to be worshipped. I have a right to worship. He is a right to be worshipped and have a right to worship. That aspect of the matter will also be seen and also contested. We will prove that it is Shivling, not fountain. Number 2, once it is Shivling, the right to worship in that premises, that portion will also be given to Hindus. And it will affect the connected matters wherein title dispute is there. So you have to see everything collectively, not separately.
Okay, so just to simplify this for our viewers, this is step number 1. The petitioners have been granted the liberty of their plea being heard. What is this plea? They are saying, give us the right to worship the Shringar Gauri which is present inside the Gyanvapi mosque. Subsequently, they are going to say, listen, there is the Shivling which has emerged from the Wuzu Khana. We want a carbon dating. We want an archaeological survey of India. study to be done over there, and all of this then will be examined by the court. So all of this happens step by step. However, it is all subject to a legal process, Kamru Choudhury. Just like the court has admitted the plea today, tomorrow it can say, sorry, you can't worship. Why are you already angry and outraged and have declared death of democracy and secularism in the country?
Padmaja, a very good evening to all of you. First and foremost, we from the Congress party, we always welcome any decision that our courts may take within the legal framework of the Indian Constitution. But then I have got a point to say about your hashtag that you are using in this program. Hashtag Hindus get justice. What does that mean? Hindus get justice from whom?
From the court, the district court in Varanasi.
After 1947 or prior to the... No, you are misquoting the entire facts out here. Padmaja, I'm very sorry. This itself is triggering. Your hashtag itself is triggering. Why I am saying this?
You know, this was about the judgment today, but for some strange reason it always boils down to analyzing the media and the hashtag. I wish you spoke about the issue itself. But since you're asking why this hashtag, I'll tell you why. Because, sir, when you pass a law in Parliament, which is the Places of Worship Act, which takes away the fundamental right of a human being or only one community to even go and appeal to court and say, can we please have a relook at the status of this temple which was taken over, you are denying them the principle of natural justice. And because this present case has taken, you know, this out of the ambit of Places of Worship Act, that's why the hashtag. Now, can you please come back to the position? Since I have explained your concerns about our hashtag, now come back to the topic. Padmaja,
now your advocate on record, Sri Vishnu Jain, says the cut-off date should not be 1947, it should be 1192 AD. Now you understand the logic behind this 1000 years, that he wants to go back and say all historical injustices that have been done in the past during the medieval era, during the Mughal era, during the British era, needs to be done so that the Hindus of 2022 get justice. Isn't that illogical a little bit? We have got millions of disputes of such sort in Indian subcontinent. Our civilization is such a big civilization, such an age-old civilization.
Why is it illogical?
Lots of clash
going by your logic, tomorrow you will say, we are in the year 2022. Why are we even talking about, you know, Gilgit-Baltistan? Why are we talking about Pakistan-occupied Kashmir? It has been over 7 decades. This is so illogical. Let us give up our rights on Pakistan-occupied Kashmir.
Padmaja.
Because 75 years later, who will fight for, you know, Pakistan-occupied Kashmir? Let's give it up. So illogical. Sir, what is yours? If somebody wants to claim it or reclaim it, it is their right.
You need to decide
you have to do it through the legal route. You can't stop somebody saying you are illogical. Why is illogical? He wants to claim his temple, or at least he or she wants to try. Why should you decide it's illogical, sir?
Then let me first say that I want the Kohinoor diamond back to India. Is
actually, you would be surprised. Somebody filed a petition to that effect. The government of India filed an affidavit to that. But there were other intricacies which came in the way.
No, don't get into whataboutery.
Sir, this is not whataboutery. You brought up the Kohinoor, so I am answering your question.
You need to decide.
And since you brought up the Kohinoor and colonialism, today countries like Antigua and Australia are actually debating whether they want to be in the Commonwealth, whether they want to keep the Queen and the royal family as head of their state.
You tell me.
That is exactly what people do. They correct historical injustices.
Padmaja,
you can't decide a cut-off date.
I just wanted to make some quick points out here. No, I just want to make some quick points out here. When successive governments, either in the British era or Indian independent era, had recorded this as a place of worship belonging to a particular community, now another side comes in and raises objection to it. The court is going to decide on the merits of the case. Today they have given a preliminary judgment that the case is maintainable. We, the Congress party, we welcome such decision and hope that a proper amicable solution is come out. But then you see, when you speak of a particular community, the minority community, or let me be very particular, the Muslim community of this country, you, in the name of acting against jihadis, you bulldoze their madrasas.
Okay,
you do not
again you are doing what about this? This is not about madrasas. You want to talk about madrasas? We'll come to it separately. By the way, sir, by the way, just a second, I will let Shriraj Nair respond to what you are saying specifically about this topic. But since you brought up the issue of how successive governments and many regimes have recorded it as a mosque, you are factually wrong there. Because successive governments, including that of the British, have recorded this as a temple on which a mosque has been built, and this is historically proven by records of the British. Point number one. Point number two, today here is what the district court in Varanasi has said in its order, saying that just because you can't see an idol doesn't mean the character changes of the place of worship. Let me quote to you. The court observed the destruction of the idol does not result in the termination of the pious purpose and consequently the endowment, and therefore even where the idol is destroyed, Mr. Kamru Choudhury, or the presence of the idol is intermittent or entirely absent, the legal personality created by the endowment continues to subsist. Maybe you cannot see the idol of Shiv, but the nature of that place as the abode of Shiv continues. That is what the district court has said today. Now let me let Shriraj Nair respond to you. Shriraj Nair, this is illogical and idiotic. How long are you going to go back? 1100 AD, 600 AD, 500 AD, the birth of civilization? How old will you go back?
See, first of all, we welcome today's decision by the Honorable Courts, and I was listening to Mr. Kamru Choudhury. Selectively, they want to abide by the court's decision. They want to selectively abide by the Constitution. They want to selectively abide by the judiciary. This is not going to work in a democracy. We need to respect the judicial system and the Constitution in totality. Now, today's judgment is a welcome judgment. Now, the Places of Worship Act does not apply here. That's the best thing that has happened today. And moreover, the Places of Worship Act has already been challenged in the Honorable Supreme Court. Why are they worried? Today, we live in a scientific age where the age of a stone also can be made out by scientific means. Let a proper survey, through scientific radar systems and ASI survey the entire place, and the way a judgment came and the way we Hindus waited patiently for the Ram Janmabhoomi verdict, which came in our favor eventually. So today, in today's world, nobody can fool. Today is a world of science and technology. So let things go the scientific way. Let the ASI take care. Let the best of the machinery being used from not only from our indigenous machinery, plus even whatever we can get it from outside. Even the case of Babri structure and the Ram temple, we had used Canadian radar service. So similarly, we can use the best of the system and find out what is beneath and what was there. So why are they worried? If truth cannot be your truth and truth cannot be my truth.
Done in an open and transparent manner.
Padmaja,
the public knows exactly what is happening. Nobody can be fooled.
May I respond?
Shoaib Jamai, go on. Why worry?
Let me respond to Shriraj Nair.
Yeah, go on.
Yes. Padmaja, though this verdict have a very meager effect in the totality of the judgment which will come on later on, but it seems like this order is under the influence of some external factors. I will not tell the name, what are the external factors, but some political parties
now it is an external factor. This is the problem with them.
India and the
if the judgment does not come in there,
responsible for this. Please try. Please.
So
please,
they are ridiculing and mocking the judges. This is ridiculing and mocking the judicial system.
that I will know, that I will answer now. Shriraj Nair, listen to me. I have listened to you respectfully. Then give the respect to other panelists. Otherwise, I have very lambi zaban.
So now, okay. So this judgment has been branded as influenced, and this judge has practically been cancelled because he has failed your test of secularism. Okay, chalo, maan liya. This is a non-secular fascist judge, but he is a judge, and you can't help it. Go.
This is my.
You challenge it, sir. You challenge it by all means.
Okay.
This must be a fascist judge.
This is my belief.
Yes. Okay. It's your belief.
Yeah.
Go on.
This is my belief, and I am free to express
of course
my words. And the thing is that
Shoaib Jamai, don't take such tension. BP mat badhao apna.
Is not only shocking.
Judgment hamari taraf se aane wala hai. Don't raise the BP.
As a society, but this kind of judgment actually no. This kind of judgment actually opened up Pandora box of the nuisance activity of the Saffron Group. That is the fear. That's why we fear that. Are we looking back to the 30 to 40 years back when there is a very dangerous situations in the country? जब वहां पे राम मंदिर का शिलान्यास हुआ, किस तरीके से मस्जिद के अंदर जो है चुपके चुपके वो डीटी रखी गई, और फिर क्या हुआ आप सब जानते हैं. अगर वो बाबरी मस्जिद नहीं शहीद हुई होती तो क्या फैसला यही आता? तो इसलिए मैं ये समझता हूं कि यहाँ पे ये कह देना अपने आप में
जुडिशियल सिस्टम हैज गिवन अ वर्डिक्ट दे डोंट रिस्पेक्ट.
पूजा मस्जिद के अंदर करनी है तो वो अपने आप में 1991 प्लेसेस ऑफ वर्शिप एक्ट को चैलेंज करता है.
अरे वो मस्जिद था कहाँ? आप कैसे बोल सकते हो मस्जिद है? वहाँ शिवलिंग पाया गया, वो हमारा मंदिर था है और ता कयामत वहाँ मंदिर रहेगा.
सूट की बात कर रहे हैं. नाउ यू विल टॉक अबाउट द टाइटल सूट ऑफ द मस्जिद. सो दिस विल ओपन द पेंडोरा बॉक्स.
No, so that too is already pending. Title suit is already pending. नई बात नहीं है. Point number one. Just a second, I am also, and since you spoke of Pandora's box and the fear is कि after Kashi there will be Mathura, I am also joined by the petitioner in the case. Dinesh Sharma ji is the petitioner in the Mathura case of the Krishna Janmabhoomi. But I think Shoaib Jamai, you did not hear the part that I read out from today's judgment, where the judge has said very clearly, just because you cannot see the idol doesn't mean it changes the character of the place. Just because the idol is destroyed or the presence of the idol is intermittent or entirely absent, the legal personality created by the endowment continues to subsist. शिव जी दिख रहे हैं, नहीं दिख रहे हैं, शिवलिंग है, नहीं है, legal endowment continues to exist, says the judgment that you have just declared under influence. ये जवाब दीजिए दिनेश शर्मा जी, ये पेंडोरास बॉक्स खुल गया है. जो बाबरी मस्जिद का वक्त था वो दोबारा हम 2022 में देखने वाले हैं. 1992 में वापस चले गए हैं 2022 से. दिनेश शर्मा. Mr. Jamai, let Dinesh Sharma answer.
Of the Singar Gauri is a very different thing.
Sir, we are talking about facts here. I will come back to you on the issue of fact and Babri Masjid. Let Dinesh Sharma answer. Dinesh Sharma, बोलिए.
In comparison to the what?
देखिए, औरंगजेब था तो उसने हिंदू मंदिर तोड़कर ईदगाह का निर्माण कराया, जबकि सभी जानते हैं वहाँ कंस की जेल थी, उसमें कान्हा का जन्म हुआ था. उस औरंगजेब ने आगे ईदगाह बनाई. तो ये तो पूरा हिंदुस्तान जानता है ना. पहले कान्हा का जन्म हुआ था, उसके बाद में मंदिर को तोड़कर ईदगाह बनाई.
ओके, ऑलराइट, लेट मी. शोएब जमाई बताइए.
अजीब सी बातें करते हैं. नहीं, ये जो बातें हैं अनंत काल कैसे कोर्ट में, हाउ विल यू प्रूव इन द कोर्ट ऑफ लॉ? आप कहते हैं आप प्रत्यक्ष देवता. व्हाट इज दिस आप प्रत्यक्ष देवता? हाउ विल यू प्रूव दिस इन द कोर्ट ऑफ द लॉ? आप हजारों लाखों साल, हजार या लाख, कौन सा वो एडी होगा या बीसी होगा, क्या होगा? आप कुछ तो यहां से रिलेवेंट पॉइंट कोर्ट में बताएंगे या कुछ आप बताएंगे. आप ऐसी इरेशनल और एक रेटरिक बातें कर रहे हैं जिसका कोर्ट ऑफ लॉ में जीरो उसका रिलेवेंस है. एंड दिस विल बी थ्रोन इनटू द डस्टबिन माय डियर फ्रेंड. तो कुछ ऐसा रैशनल बात बताए जो केस की मेरिट को मजबूत बनाता है. आप एक एक्सटर्नल इन्फ्लुएंस करके कोई चीज को मेंटेनेबल करा लेते हैं, दैट्स अ डिफरेंट थिंग. 7/11 का वो केस है जो उसको मैं मानता हूं ये गलत है, लेकिन ये 7/11 का केस में आप खुद आप देखेंगे कि ये 1991 के प्लेसेस एक्ट को यहां से चैलेंज कर रहा है, बिकॉज आप मस्जिद के अंदर अगर श्रृंगार गौरी की पूजा करने की बात करते हैं तो एक जहां नमाज हो रही है वहां आप पूजा करेंगे तो वो ऑब्वियसली कैरेक्टर को चेंज करेगा।
You are saying that this is going to open the Pandora's box for the saffron groups, just like the Babri Masjid. Let me actually remind you that the locks were opened in Ram Janmabhoomi not by any saffron group, but it was opened by the Congress government, something that Digvijay Singh even claims today very, very proudly while he's on his Bharat Jodo Yatra. So saffron group ने नहीं खोले थे मंदिर के ताले, आपकी प्रिय पार्टी कांग्रेस ने ही खोले थे. Let me bring in Mr. Zubair Memon as well. Zubair Memon, today for very long, Mr. Asaduddin Owaisi has said that Places of Worship Act hai, how can you have any of these pleas? Today the court has said, and I quote, the main argument of the Learned Counsel for the plaintiffs is that plaintiffs have not sought declaration or injunction over the property land plot 9310. They have not sought relief for converting the place of worship from a mosque to temple. The plaintiffs are only demanding right to worship Ma Shringar Gauri and other visible and invisible deities, essentially saying that the whole argument of Places of Worship Act doesn't stand only.
Today's court's judgment, if we go through it, nobody can deny the fact that from last few centuries, day in and day out, daily in 24 hours, 5 times Muslims are worshipping in the masjid. Second point, today's judgment given by the local court is completely coinciding and superseding the Supreme Court judgment of Babri Masjid and Ayodhya verdict.
But sir, you are forgetting the fact that the Hindus also were non-stop worshipping Ma Shringar Gauri in the same compound till 1993. They were constantly worshipping. It's just that the Samajwadi Party government stopped their constant worship. You remember that 5 times a day namaz is being offered over there, but you have forgotten that before 1993, puja was being done. For centuries. Even Hindus were worshipping for centuries. Right up till 1993.
No, you are falsely quoting the facts.
Sir, it has been recorded in the court judgment today.
Hindu was...
And there are documents, there is a map, there is testimony of people who were present there in 1993 and said, how puja karte the andar jaake Shringar Gauri ki roz.
You are giving false facts, ma'am.
Okay, let me quote.
You are giving completely false facts.
I do not, sir, so let me quote to you from the judgment.
I'm sorry to say that.
They have not sought, okay, the plaintiffs are only demanding right to worship Ma Shringar Gauri and other visible and invisible deities which were being worshipped incessantly till 1993 and after 1993 till now once a year under the regulatory of state of Uttar Pradesh. This is a fact, sir. This is not fakery. This is fact. Till 1993, Hindus were praying incessantly.
No, ma'am. You are completely mixing the facts. When you mention Shringar Gauri, they till today, once in a year, they till today worship there. And there's no one lying or hiding the facts. The fact is that there's a masjid there and it is protected by the law given by the Indian courts, the Religious Practices Act. And the main thing, what we are debating, the judgment of today's court that completely supersedes the Babri verdict. If we accept the Babri verdict, or the persons who are accepting or the celebrating the Babri verdict, they should know what the Babri verdict said. It clearly stated that it's the final case and the case would not be used as a citation or would not be used in any other masjids or mandirs or religious places.
But the Babri verdict hasn't been used here. This is an independent plea. Shriraj Nair, this is subverting the Babri verdict.
How come?
Because they are just saying we used to pray there, we want our right back to pray there. Simple, that is a simple prayer. It's got nothing to do with the Babri verdict, sir. Here is where you are misleading.
It has completely.
Madam Padmaja, I want uninterrupted 1 minute.
Okay, you have uninterrupted time for a minute. Yes.
Please, you have spoken, we all heard. Don't beat around the bush and don't repeat same. See, Madam Padmaja, I belong to the state of Kerala, which is the southern part of the nation, and before the industrial revolution, before the transportation came in existence, before motors came in existence, people from Kerala and down south used to walk to Kashi. That is the importance of Kashi for irrespective of Hindus, wherever geographically they reside. That is Kashi. And what has Gyanvapi or so-called Gyanvapi structure, what they are holding, what has Islam, what relevance it has got? Even in Saudi Arabia and all the Arab world, mosques have been raised for making infrastructure like hospitals and roads. Here, rather, giving, they should respect. Today, a decision has been taken by the Honorable Court, and now the place of act of worship is not going to apply on this. The case is going to be now fought on merit. Let the merit decide. Why are they beating around the bush? Why and what are they scared of? Today, they are the people who want to take the world to the Stone Age, but they forget today is a world of science and technology. There is a system which can identify everything. So let the ASI and the scientific technology find out what exactly what exactly is there. They don't need to jump the guns, and moreover they are mocking the judiciary.
Mocking the judiciary, and it seems very strange, sir.
What the Honorable Court
seems very strange that in another case, when we are talking about the hijab, at that point, the counsel for the petitioners there says, oh, you cannot try and interpret our text because that would be blasphemy. You question the very Indian Penal Code by bringing up the issue of blasphemy. And here, when you have a bunch of petitioners who are going through the Indian Penal Code route and saying, we need our right to worship, you say, why are you doing it? Why are you going to court? Because that is the legal process in our country, Mr. Memon.
The question is, one religious place situated in Kashi or anywhere in India is being worshipped daily by the Muslims, or let it say by a community. They have been worshipping there for centuries. Just to hue and cry and make a communal debate is just unjustifiable and it's unconstitutional. It's unconstitutional and it's unjustifiable, and it has no logic or base. What kind of proofs are you going to find out there that the Muslims were worshipping for 200 years or 300 years or for centuries?
Sir. You are asking what proof do you have? That cannot be decided on a TV debate. That will be decided in court. Let the court hearing happen. And I have to point out the irony of the situation where going to court, seeking your legal right is being deemed unconstitutional. I don't know then what would be constitutional in the country. I'm going to leave it at that. Important development today nonetheless. Thank you very much all gentlemen for joining me.